pre-conference session of the 8th Emerging Markets Conference. Apparently, when I first sent out email inviting people to the Emerging Markets Conference this year, I said, welcome to the 7th Emerging Markets Conference. Apparently, no, we are older than that, right? We aspire to be young, but we are actually older. It's with great pleasure that I want to introduce this group. We thought that we shouldn't make it too onerous for a pre-conference dinner. But this group is basically going to have a chat about one part of the insolvency and bankruptcy code that really hasn't had sufficient traction in the public, but it's something that concerns us a lot more than what is actually on the floor, which is the individual provisions of the insolvency and bankruptcy code. And I could go on, but that'd be really dull. So what I'm going to do is hand over the floor to Adam, Renuka, and Bindu. And I would request each of you to take a minute and speak about yourselves, and then you have 35 minutes to do your little conversation, enlighten us about what Adam's thoughts are in terms of the insolvency and bankruptcy code individual provisions. Bindu has a really nice role in the sense of being a person who's working with the regulator to operationalize some of this stuff, or actually design the operationalization of some of this stuff. And of course, Renuka was part of the original team that thought about the rationale of the provisions that are in the code. So I think this is a magical group. And without further ado, floor is yours. Renuka is going to do the moderating, although I don't know what that means for a conversation. But I think that Adam and Bindu are the people who will have the main conversation. All yours.
Shall I start?
Sure.
Okay.
I mean, now the floor is yours.
Can you hear me? Am I? All right. As per your request, I'm Adam Feibelman. I'm a professor at Tulane Law School in the U.S., but I've been here this fall and last fall in India studying India's new insolvency and bankruptcy code, especially the provisions that pertain to personal and household debtors. And so I'm actually here to learn from all of you, so I'm going to try to keep my comments as brief as possible to leave more time for the conversation. But first, I do want to thank everyone here at IDR for including me in the program. So as most of you are aware, I guess everyone in this room is aware, the country adopted an ambitious, comprehensive new insolvency and bankruptcy code covering both commercial and household debtors about 18 months ago. Notably, the code does not cover financial firms and did not or does not yet include provisions on cross-border insolvencies. The system for commercial debtors went into effect around a year ago, and despite a lot of hand-wringing at the time, I think it's functioned better than most would have predicted, but we'll hear much more about that tomorrow. The provisions for individual debtors, personal debtors, have not gone into effect, but there's a working group, which Bindu is a member, preparing regulations, and perhaps it will propose some potential reforms as well. And officials have indicated that the provisions will be at least partially put into effect in the coming months. From the beginning, the provisions for individuals were, I think, nearly completely overshadowed by those for commercial debtors. And that's because the motivating forces for the code related to corporate debtors. In the interest of time, I won't describe those. They're familiar, I think, to most people here. But it was, I think, understood the motivation for including a personal insolvency provisions at the time was because it was deemed necessary to do that to deal with business insolvencies, since so many businesses were sole proprietorships, SMEs, or family firms, such that the finances of the firms were inextricably tied to their promoters and guarantors. And in fact, it appears that the personal insolvency and bankruptcy regime will go into effect first for individuals with business-related debts, and then later for those with personal debts. My comments are directed primarily at how the regime will deal with personal debtors, but I think that many of my observations hold for individual debtors with business-related debts as well. For those of us who study consumer bankruptcy regimes around the world, India's adoptions of the provisions of the IBC for personal debtors is really a rare case, I think. Generally, when countries adopt or modernize their consumer bankruptcy or insolvency laws, it's in the midst of a financial crisis or in the wake of alarming levels of household over-indebtedness. Especially since the global financial crisis, however, there's a growing consensus that a consumer bankruptcy regime, or that consumer bankruptcy regimes are systemically important because they can serve a crucial safety valve in a crisis or pre-crisis and can help expeditiously allocate losses. But a well-designed, well-functioning consumer bankruptcy is also arguably an essential part of the infrastructure of a stable and resilient consumer financial market in more fundamental ways. It can serve as an insurance function that protects borrowers to some significant degree from the risk of financial distress, allocating that risk to creditors who ideally respond by pricing credit accordingly. That pricing function, potential reputational harm, and other factors ideally mitigate the possible moral hazard created by the protection afforded to debtors so that the insurance function provides some discipline to both creditors and debtors. So ideally, it helps reduce ex post social costs of individual financial distress and serves an ex ante function that reduces the overall amount of household indebtedness in an economy. You'll let me know if I'm running over time. Assuming that what I've just said is a plausible story. Susan will let me know if I'm going. Assuming that what I've just said is a plausible story about consumer bankruptcy, I'm interested in anticipating how likely it is that the Code's personal insolvency and bankruptcy provisions will serve these functions and operate in this fashion. And in sum, my working conclusion is a cautious yes, it will, but less, perhaps much less than it otherwise might. The new regime will definitely provide a greater degree of protection and insurance for debtors and will prove more useful for creditors than the presidential and provincial towns insolvency acts, which are still technically in force. And which are basically late 19th century insolvency laws, cumbersome, providing uncertain relief, and imposing significant prohibitions on insolvent debtors. Not surprisingly, they were only used in exceptional cases. The new provisions streamline eligibility, make at least some degree of relief relatively automatic, and include strict time limits and require relatively little judicial function. So the system should be more expeditious and over time more routinized and predictable. I think we're beginning to see this is at least generally true of the corporate regime that's been operating for the last year. But again, more on that tomorrow. I do think, however, there's a significant possibility that the personal insolvency and bankruptcy regime will primarily function, at least in the short term, as a creditor's tool for collecting debts, and that the insurance function will be, let's say, suboptimally modest. My prediction is based partly on the design and structure of the provisions of the Code and partly on contextual factors that will likely be barriers to voluntary use by debtors. First, regarding the Code itself, there are 3 chapters, a fresh start for low-income, low-asset debtors, and the insolvency and bankruptcy chapters for everyone else. The fresh start chapter is actually extremely generous to debtors who use it. It's basically a loan waiver provision that does not provide for any distribution to creditors. But eligibility requirements are quite narrow. No more than 60,000 rupees in annual income, 20,000 in less than 20,000 in assets, and less than 35,000 rupees in qualifying debts. And you can't own your own home. So there's obviously a large portion of the Indian population who fall within this category, but it's not at all clear how many of people in this category will have enough debt to warrant filing. And again, they can't own their own home, so they won't use it to avoid foreclosure, which is a reason that many people file in other systems. My guess is that most of this subset will have borrowed from informal sources or MFIs, but that's something that I'm quite curious about and we'll talk about, I think. So in addition to that kind of the structural impediments, the practical, social, and cultural factors may result in many of those who might employ the fresh start not to do so, including lack of knowledge of the regime, difficulty in navigating the system, especially in rural areas, direct costs for professional help or advice, and time, and stigma and other reputational, related reputational concerns. To be clear, even if a small percentage of eligible debtors apply for a fresh start, that could still represent significant, perhaps large actual numbers. So the system will need capacity to deal with them. And suppliers of credit in this space will presumably need to adjust. But my concern is that too few of the overall number of individuals and households who could benefit from a fresh start, for whom the provisions were designed, will employ it. For most debtors with significant amounts of debt, then the insolvency and bankruptcy chapters will be the relief and protection available to them. The bankruptcy provision actually provides a good measure of relief because it ensures that debtors can discharge debts that aren't paid off from their non-excluded assets, unsecured debts, I should say, that aren't paid off from their non-excluded assets. And this is roughly similar to the Chapter 7 in the US, which actually most debtors use, and there they can choose which chapter to use. And in the US, most Chapter 7 cases are actually no asset cases, meaning that there's no distribution to unsecured creditors. But the new IBC requires that debtors first file for insolvency, right, before, as a prerequisite to entering the bankruptcy chapter. And to do so, that involves proposing a repayment plan to the creditors, and then they can only file for bankruptcy if the plan is rejected or if it ends unsuccessfully. Meanwhile, the insolvency chapter doesn't provide much to limit or guide the design of repayment plans. The plans must only provide a minimum budget and protect so-called excluded assets, what elsewhere we would think of as property exemptions. And it's safe to assume that creditors will insist on payment from all of the debtor's assets and income beyond the minimum budget and excluded assets. So as an aside, I think one of the most important open questions is how the minimum budget will be determined in these cases. For example, will it include payments to secured creditors on a home, in a car? This is an issue that arises elsewhere. To be clear, the insolvency process can still provide many debtors with significant debt relief, even if the minimum budget is very strict, but it will presumably be quite unappealing to many who would nonetheless benefit from it. Added to which, many debtors who would benefit from insolvency and a chance for bankruptcy relief will face many of the same practical, social, and cultural barriers that low-income, low-asset debtors face in utilizing the Fresh Start provisions. For both pathways, Fresh Start and the insolvency bankruptcy backstop, then again, I think there are good reasons to be concerned that too few of the debtors who are the intended beneficiaries of the new insurance will take it up. I happen to believe that most of these debtors, or at least a lot of them, will be honest and unfortunate people. And, I'll say why that matters in a minute. I could be totally wrong, and it could turn out that individual debtors end up utilizing the Fresh Start and insolvency provisions in large numbers, perhaps often opportunistically after borrowing irresponsibly. If so, then consumer financial markets will have to adjust somehow, and I think this would be a potentially big deal for suppliers of credit in this space. I think it could also be a fascinating example of law having a significant impact on culture if people behave in ways that we think they would not. But again, I'm inclined to think that this is unlikely to happen, and that the personal provisions of the IBC will be, at least initially, primarily a creditor's remedy. And if it's perceived as such, that could reinforce the reality, right? If debtors view this as a creditor's tool, they may be less likely even to file voluntarily. That would not necessarily be a completely bad thing. It could help increase the supply of credit in the economy, especially unsecured credit to individuals and households. And in any event, the law, I think, will definitely provide more protection to debtors than the old insolvency acts. But the regime might well end up providing a suboptimal amount of insurance against the risk of financial distress, and if so, fail to live up to its promise as a tool for reducing the micro and macro effects of household financial distress. if both things happen, namely if the law promotes increasing supply of credit but doesn't serve a robust insurance function, then that could be the worst of all outcomes, right? Because then that could actually accelerate instances of over-indebtedness in the economy. And fail to provide a safety valve in the event of a looming financial crisis with systemic consequences. So in the last minute, just quick 4 themes. One is, do we think that there's an ideal scope for the fresh start? Is it in the code? Do we think that, that it should be more or less available? Again, I mentioned an important question is how the minimum budget should be determined. I think that is going to end up being quite important. Another important thing is that I think there will definitely be a need for outreach and education in the, among the potential beneficiaries and users of the new regime. And lastly, I think for the system to work, and this is something I believe about both the corporate and the personal side, I think that there probably must or inevitably will be a change to some extent in the attitude about debtors and promoters. I've been quite struck since I've been here at how people seem to universally think that debtors and promoters are all cheats and liars and opportunists. Or at least this is something that comes through in conversations. And that there may be some real truth to this, but my guess is that it's overstated. And in any event, in my view, a bankruptcy system, a successful bankruptcy system, has to be premised, at least in part, on the idea that failure happens, losses must be allocated, and that it's better for everyone if failed debtors, commercial and personal, are generally able to return to productive financial lives, despite their failures, mistakes, and in some cases misdeeds, without bearing the full weight of those misadventures. I'll stop now. Thanks.
Thank you, Adam, for those wonderful comments and the paper. Let me quickly just, I think, share some high-level thoughts triggered by the paper, and then maybe we can have a bit of a conversation exchange. I think one of the things that for me, the paper really reminded me was that this is really an extraordinary policy experiment that we are having an insolvency, bankruptcy, fresh start regime in an environment where many of us are simultaneously advocating for very basic access to finance. So, you have this sort of 2 ends of the spectrum. In fact, when I sit on the committee, I face extreme cognitive dissonance because we are talking about creditors' committees coming together and discussing, whereas, most of the time we are saying, well, there are not enough lenders, credit to GDP, in most districts in India, single digits, and we really need to. So I think the overall sort of question that you posed to say, given that for a number of maybe even accidental reasons, the fact that we have this regime, superimposed by the fact that we do have basic access to finance challenges, how do we end up making this a good thing for the end consumer? And what does that journey have to look like? I thought that whole premise and question was very thought-provoking. And it also definitely sort of races therefore the spectrum of unintended consequences and what are the risks that it poses in general to consumer finance markets. So in that sort of context, I wanted to bring up this notion of today where we find ourselves on retail credit, particularly for low-income sort of middle-income consumers, is that we actually have a fair degree of standardization of loan contracts. So if you look at micro loan contracts, these are typically 52-week, fortnightly payment type issues. We did some work in a district of Karnataka in which we followed a set of borrowers through the whole loan cycle for about a year. And going in, our hypothesis was that, well, these are borrowers who seem to display very high rates of repayment, so 99% plus, which already is sort of a puzzle if you think about it. But we went in saying that, well, high repayment rates are not generally equal to good outcomes at the household level. So let's go in and understand what's happening there. And bottom line, what we found was that if you look at the loans that were actually made, 1 out of 5 of those loans, even to start with, should not have been made at all, just from a filter of debt service capacity. In a static sense, does the household have enough income to service those loans? 1 in 5 actually flunked that test, yet at the same time you see sort of 99% repayment rates. Another sort of 1 in 5 through the course of the loan because of shocks, health type issues, turned insolvent for a brief period of time before they sort of got back on their feet, either through other borrowings, friends, family helped out. So the broader kind of question thing that I've been thinking about is that in the spectrum of reform in this market, how do we get at issues like flexible loan contracts, which we know makes a big difference? Does the fact that we now have this big insolvency, bankruptcy, fresh start, does that slow down some of the more doable supply side reforms, such as moratoriums on loan contracts, restructuring? It's shocking how little restructuring happens, even in the face of fairly extreme events like Chennai floods 2 years ago. All lenders pretty much stuck to contracts because of the way provisioning, etc., happened. So I just wanted us to think a little bit about what needs to happen in the middle of the spectrum that effectively complements good outcomes for consumers. The other, Adam, you raised the issue of you worry that the insurance element may not be enough. I actually have the opposite concern. So if you look at, and this may be my provider hat speaking, but if you actually look at microfinance regulations and that customer profile, in fact, the regulation almost exactly mirrors the provisions of the Fresh Start. So it used to be that microloan customers necessarily have to be 60,000 of annual income, which is what the Fresh Start also prescribes. More recently, that was revised to 1,100,000 rupees. If you ask me, are those truly the incomes of those households? Not at all. But because the regulation hard codes the fact that MFI customers must necessarily have this income profile, a whole industry of auditors have developed that will sort of rubber stamp that loan application to say this is household income and how can you prove it otherwise? So what really, if this rule gets notified, as we speak, about 10 to 15 million microfinance customers, because of the demonetization type long tail, are actually today not been paying. This is a market of about 25, 30 million customers. What if all of them, just as a thought experiment, what do providers do? How does one sort of respond to that issue? Very likely, just the fact that people are not aware of those rules, etc., means that it might take time. But I actually think that the insurance element, given the microfinance sort of market maturity, may actually be something real. Something for us to think about. And the final point I'll kind of leave, and Renuka, we can have a bit of a conversation, is around a lot of the ways in which government, we've provided insurance to this profile of individuals, proprietors, sole proprietors, etc., is fairly blunt instruments such as loan waivers. We saw a lot of that earlier this year. Suspension of licenses of private sector entities like microfinance institutions. Does the fact that we have now insolvency, bankruptcy, fresh start, does that in any way tie the hands of government from sort of unpredictable, blunt instruments which are ostensibly about providing insurance? Is that something that one can think about as being substitutes? Let me kind of pause there and we can take a...
Thank you, Adam, and thank you, Bindu, for those wonderful comments and thoughts. Let me then begin by posing questions on what Adam has said in the paper and some of the comments that you made on this whole process. Okay, so one of the things that Adam says in the paper is this whole question of that's the larger theme, which is the insurance function of a bankruptcy procedure versus the creditor remedies position. And so, one way that we should answer that question is by saying, where do we want to go in terms of what kinds of credit markets do we want to have? So, for example, do we want to have a US-style credit economy where there is a lot of free-flowing credit, and I don't know how the bankruptcy process in the US ties with the way consumer credit has been working in the US, and perhaps you can help us think about that a bit. Or do we want to be more conservative, India-like, where credit to GDP is a little low? Because the answer to this helps us think about how important is the insurance function for us and how important is the creditor's remedy function to us. And so, your thoughts.
Maybe the US.
Yeah, so I feel ill-equipped to answer the question of what kind of credit markets, people here want as a matter of policy. My sense is that, it strikes me as a society with a high degree of entrepreneurial drive and at least demand for credit where it's available. So, my sense is that it's at least a candidate for a place with a much more robust credit market, which and support for risk taking, which means that there will be a predictable degree of failure, and so you want to build in a tool that allows for failure, and then it doesn't clog up the system like with non-performing assets now. That's on that. I had other responses to Bindu's.
Just quickly, I know you don't like the answer, but, why can't we have both? And I would say that credit supply is definitely an issue, right? In my mind, that's an important, binding constraint for many districts in terms of, agriculture development, jobs, etc., etc. So clearly, we need to do more on that, and so for that, we need more provider side participation, just more entry of firms. We have too few banks in this country that are chasing down these opportunities. So all of that is important. At the same time, I think where having a bit of a safety net insurance element matters is to give some predictability even to some of these financial firms, because it's not like the government is going to sit by and let a distress play out. They will intervene in blunt ways. So in a way, if the insurance mechanism, whatever it is well defined, to me that feels like it actually gives more certainty to financial firms to enter these markets.
Did you? I had.
Okay, I have one question
Please.
for you, but then perhaps I can ask after your question to Bindu.
Well, I was just going to respond to some, if that's okay, because it occurs to me that you could think of two possible futures that actually encompass a lot of your thoughts and comments. One would be the rosy scenario, where once the law is in force, a number of borrowers come forward and say, "Look, we're actually, we've been making payments, but we can't anymore." Or the 1/5 or 2/5, depending of how you would describe it in your study, or the long tail. And in the rosy scenario, you would say, well, don't file, let's work something out. And kind of system-wide, creditors would do this in situations where they wouldn't previously. In other words, that the law encourages more informal renegotiation. Now, I'm not sure if I've understood what you're saying about whether the contracts preclude this or not. This was actually a big problem in the US in the financial crisis, where a lot of the mortgage-backed securities, the trust arrangements with the mortgage servicers, I'm not sure, maybe people are familiar with this, expressly prohibited the servicers from renegotiating or participating in bankruptcies. So it could be that the contracts actually preclude this rosy scenario.
It's not so much the contracts per se, it's more that upon restructuring, the provisioning requirements and therefore the balance sheet effects for firms can be quite penal.
I see. Yeah, so then that would be a regulatory, that's something where then the regulators could play a role. But again, the rosy scenario might be that the law facilitates kind of allocating these losses quickly, even if it doesn't result in a wave of actual filings. The less rosy scenario is that it doesn't, and there is like a real wave of filings. And I hadn't, part of my point is that there isn't an acute crisis now. But what you've described with the kind of effects of demonetization, maybe there's more of a crisis out there looming, and there could be a real wave of filings as soon as the law is enacted, which, as far as I can tell, nobody is prepared for.
So suppose there were filings, okay, and one of the points you make in your paper is that you have to go through a insolvency resolution process before you get to a bankruptcy. But when the law was being drafted, at least we felt that not having the IRP and allowing people to go straight into bankruptcy leads to other kinds of troubles, which is that the person doesn't even get a chance to restructure or make a case for repayment and not have bankruptcy against her name. In that case, so the point that you make in the paper is that this is a lengthy process to go through the IRP. Why not have a fast track bankruptcy for individuals at all? And I think that is the concern, which is, should people not have a chance to restructure? And because the power is in the hands of the debtor, which is if the debtor does not say yes to the plan, then the plan doesn't go ahead anyway. And if you have rational actors, which is creditors and debtors, in the negotiation, would you not see better outcomes when you sort of let this be, other than just allowing people to go straight into bankruptcy?
Just an add-on to that, but I think one of the concerns that Adam flags in the paper is it's not clear if the debtor does not consent to the plan, that itself is grounds to kick it into bankruptcy. And so how much of a loose...
That's true. There we have to worry about what power the DRT has and under what conditions can it say yes and no. But that is a solvable. Maybe regulations can look at how this process should get to the DRT at all. But at least the intent when the law was being written was that the debtor should have a say, and therefore he is allowed to participate in the resolution process. And if it's not going to go anywhere, the creditors see it, the debtor sees it, and you agree to go to the bankruptcy process. Totally.
Yeah. So, part of my difficulty in assessing the code is that, again, the system that I'm most familiar with, the bankruptcy provision that is the backstop of the IBC, is the provision that most debtors choose voluntarily to utilize when they file. So the bankruptcy provision is like our Chapter 7, and the insolvency is like our Chapter 13, which is a wage earner repayment plan. And for the most part, most people file Chapter 7 voluntarily, and that provides them much more generous relief, and it avoids them having to try to propose a plan, and then if the plan is accepted, try to live within a very strict minimum budget for 3 to 5 years, and have to go through that process to wait for any discharge. So, I don't know that wouldn't be more appealing to debtors here as well. And if so, I wouldn't necessarily think of it as giving them an option to propose a repayment plan as much as forcing them to go through this process on the way to what they would ultimately prefer, which is just, let's get this over with. I'll give you what aren't my excluded assets, but I get to keep my wage income, for the foreseeable future. But I do think that one thing that will have to be resolved early on is what exactly are the eligibility rules for getting into bankruptcy, and what the tribunal can do in terms of policing plans and determining when there's a rejection of a plan that is the kind of one of the main eligibility requirements.
You know, this brings me nicely into my next question, which is again in the paper you say that a lot of things are not in the code and they are sort of left to be determined at a future date. And perhaps part of the reason for that was that we want regulations to decide these things because it's too early to embed these in the code. So already, you know, for example, the thresholds of the fresh start would have been better left not embedded in the code. Okay, so similarly, these kinds of, you know, the point that you make about priority in the repayment plan or there not being any rules in the repayment, when the repayment plan is made. I think at least in India, our concern always is that we write too much in the law and we get very prescriptive, and therefore there is always the danger that once you start embedding this early on, there will be no flexibility left for different approaches by, you know, in different circumstances. And that makes it important to let this be and let regulation decide, or let committees of creditors and debtors decide what works for them, because who knows what that situation would be. And, you know, what would your view be in terms of codifying a lot of the how should the repayment plan be done in the regulations if they come out?
That certainly sounds sensible. And then I think a big assumption we are making is, of course, which you bring up in the paper, that a lot of it depends on the actual capacities of the resolution professionals to sort of engage on the contours of what's a good repayment plan such that it's acceptable to creditors, etc. So I want to kind of get your quick thoughts also on, given where we are and we have real human capacity issues. I mean, all of us struggle to find staff for lending operations.
Right.
And unlike the corporate here, the nature of incentives for resolution professionals to actually actively engage in this still not very clear, at least to me. What are some of the issues? I think the code does a wonderful job of envisaging the institutional framework of the board, the insolvency professionals. And I know it's very early days, but what's your sense of what that path around building those institutions actually looks like, given that we are at early days of the consumer market itself?
Yeah. I don't know, and I think probably people here and in the conference who have a better sense of this than I do. But I can say that, you know, we were here last year with similar concerns about the code as it related to the corporate debtors, and the, you know, the system adjusted and accommodated. It seems to me quite quickly. But, you know, the number of cases that are involved and the number of, you know, as you mentioned, like we think of capacity in terms of how many DRTs there are, right? But capacity is also how many officers are there and affected lenders who are going to then be engaged in renegotiating in the advance of filings, and then participating in the cases. If as you know, even if a tiny percentage of 1.2 billion people file, that's a huge undertaking. Now, I do think that it's promising, perhaps in this regard, that there seems to be this kind of initial step of notifying the code with respect to this kind of small subset of debtors. I think that'll help in identifying things that need to be addressed by regulation, and will at least help train an initial cadre of insolvency professionals about these kind of chapters of the code that nobody's looked at yet. And so maybe this can be sequenced in a way that's, but I mean, you know, I'm a bit surprised that there isn't more, given that this is at least potentially something that could happen in the year's time, that there isn't more discussion in general and more kind of hand-wringing in industries like yours about how exactly this is going to play out. But especially if it's true, you know, I'm now more concerned about this possibility, kind of hidden, lingering effects of demonetization in the especially among the population that is the intended beneficiaries of the Fresh Start. It could be a bigger wave than than I've been thinking even. So.
So I think we are running out of time. So any final thoughts, Bindu? Okay, so should I just open the floor to discussions? Any questions?
I just have two thoughts. To look at the Canadian banking system, the SME loans are probably around 60, 70%. And the rest is sort of investment banking. And as you very, very well know, Canada has done pretty well during the crisis regime. So I think perhaps one of the questions was, can we learn from US? I think definitely you can look up a little bit into Canadian banking in terms of how it was able to tide over some of this. Um, uh, in terms of the SME and consumer, I think a lot of it is mortgage and non-consumer, non-mortgage loans, and I think even there are very good safeguards in place in the banking system, in Canadian setup. The second point is, at least in a sort of common man's perspective, I think the problem of defaults in India are not the small microfinance people, but really the big guys, right? So I think which is where banks really have a tough time in getting back the loans. So I just sort of, without getting lost in the legal language, just like someone sort of man on the street, that's the sort of perspective you have. Is that correct perspective? Is that where a lot of effort needs to be put in terms of figuring out the bankruptcy code to how better sort of get back the big loans? Is a sort of question that sort of lingers in common man's minds. Thank you.
Sequencing of things, but that's why I think it'll be important, just as a side note, to have good available data about the system and what it's telling us about the economy, and whether they're kind of smaller level debtors in what numbers that need this type of relief.
So, just a quick, I mean, we serve about 130 NBFCs that in turn serve about 25, 26 million low-income households and businesses. Our own lending data is, has until demonetization been a no credit loss portfolio. But part of what I worry about is, what I was referring to earlier, high repayment rates is not equal to financial well-being. That because the stakes are so high, because particularly under MFI rules, etc., credit bureau reporting has become very stringent for low-income consumers. It's kind of optional at the top of the pyramid. So access to that next loan and therefore keeping your credit record straight. So people are actually cutting back on consumption sometimes to repay the loan. We should worry about that. And therefore the opportunity for a law like this is both from the debtor's side, of course, on NPAs, but also the insurance function, I think that.
The teeth should be more, there should be more teeth on the other side than this.
So, before I ask Anjali to ask her question, I just want to respond to that by saying that it's true that, while an insurance function is very important, it's true that either process does get you a bad credit score, and therefore the stakes can never be too low, right? And so to some extent there is always going to be pain when you go through this process, whether you get rid of your debts entirely through the bankruptcy process or not, and that will always shape decisions on whether to cut consumption or not. And maybe it's not such a bad thing if financial well-being goes down while you're trying to protect your credit score, because in the long run that's a better thing for you to do. But Anjali.
Can I ask you? No. See, the corporate sector credit market is heterogeneous, but the individual sector of the credit market is much more heterogeneous. And from what I heard just now, we heard about the consumer credit more from the urban point of view. I think there it will serve some purpose because those who are borrowing excessively, perhaps against their credit cards and so on, well, if they have any opportunity to restructure their credit, it would be helpful. Microfinance, the repayment is pretty good, so whether this will serve an additional important use, uh, one can yes say yes, it will do some. But I am worrying about the overall agricultural credit market. You see, where when you say individual, this is you said this is inclined to favor the debtors. When I began to look at the individual chapter, the chapter on individuals in this code, I thought that all those low limits etc. are placed because we are talking about the rural, maybe agricultural borrower and so on, and we have not had any discussion here about that, except that we heard some mention about loan waivers. Now, here you see, uh, the main worry is the money lender, often gave, lends to the farmer, and then eventually the farmer tends to lose the land. Now, will that be precluded by any such resolution process, or the fresh start, will that help the farmer in that way? This is the worry which I have. Secondly, you see, the farmers' loans recently saw the loan waivers everywhere, many of the states. Now, if there is a good resolution mechanism, what it would do is put the pressure away from the government to individual resolution processes, and that will be good if this can be done. If really speaking, if you can say resolution should be always an individual matter between the creditor and the borrower, whether it is a bank which is giving loan to the farmer, or even microfinance institutions, or even individuals, money lenders registered, who are registered. So there we can see a benefit that the pressure can be taken off from from this being a politicized activity to more a resolution which is based on certain definite legal and economic principles. So this is a major advantage. So I would like to know more about this aspect. What would be the use, applicability of this code to the rural scene particularly?
Just very quickly, one, I think, an important question, and that we've talked about actually, is a lot hinges on whether the agricultural debts are secured or not. So to the extent that they're secured by, say, land, then this isn't going to, I don't think this is going to be very helpful. To the extent that they're not secured or undersecured, then it could be applicable. And then, I mean, really, one way of thinking about this is it's a form of crop insurance, right? And in that case, or maybe that's, I'm not committed to defending that, but it would be a way of, then it would serve an insurance function in the agricultural sector. That those debts could be discharged. What's that? Yes, very high priced insurance. So, but and then in that case, I think we would be worried. It may provide this protection to debtors, but then we would be worried about the effect on the agricultural credit economy. That's a whole subset that I think we would.
Now, on this insurance point, just one more thing. You mentioned crop insurance. Initially, when the crop insurance was being discussed in this country, the proponents of the crop insurance, Professor Dandekar and others, they thought about it as necessarily going with the credit. And so it was always a credit-linked crop insurance that they recommended. But when crop insurance was implemented, the credit link was forgotten about. And I think if this code brings back the credit-linked crop insurance in some manner, that will be a great advantage, because that will make crop insurance more successful and also credit more secure. Thank you.
Okay, I think we've run out of time. So thank you, Adam, and thank you, Bindu, for this session. And thank you all for the questions.
Thank you. Thank you.
So dinner is outside. Please grab your plates. Whether you like it or not, we've got one more exciting discussion post dinner. So can we have all of you back here at around 8:40? Thank you.